This is Colin O'Keefe for LXBN TV. The Supreme Court handed down two landmark rulings yesterday on same-sex marriage, one with regards to the Defense of Marriage Act and the other on California's Proposition 8. Joining me now to discuss these rulings after joining us last time to discuss the oral arguments is Littler attorney Susan Hoffman, author on their blog, Employee Benefits Counsel. Susan, the last time we spoke, again after those oral arguments, you predicted yesterday's outcome pretty closely, that DOMA would be struck down and that the Prop 8 cast would be remanded for lack of standing. But was there anything about these opinions that surprised you?
One thing that surprised me is that I predicted that DOMA would be struck down on federalism grounds by a 5-4 vote. And while Justice Kennedy didn't technically apply federalism grounds, the way he narrowed the class essentially made it a federalism-type decision. What he said was that once the states that chose to approve same-sex marriage decided to do that, he in effect took the federal thumb off the scale. He allowed the states to let the political process play out in the various states and said the federal government can't come down on one side and thereby take away rights that its state has chosen to protect. But in doing that, he didn't say that these were rights of homosexuals. He didn't say these were rights of same-sex couples. He said these were rights of people who were married to spouses of the same sex under valid state laws. That's a very narrow class, and it's in effect saying we're going to leave this all to the states. And he got there by going through the history of how marriage has historically been left to the states, except in very narrow circumstances. So that aspect of the case surprised me a little bit, not in terms of the outcome, but in the way he got there.
I see. So second here, what does this mean for employee benefits, for employees in same-sex marriages?
Well, there are a number of aspects of the ruling. The obvious first easy aspect is if you're married to a spouse of the same sex and living and working in a state that recognizes that marriage, then you are going to have all the rights and privileges of spousal benefits that are required under federal law. That is one thing we do know. There's a lot we don't know. And it's those open questions that are keeping me up at night and struggling. And I'll sort of go through the general category of those questions. Number one is, can an employer who's in one of those same-sex marriage states apply narrower definitions of spouse or those aspects of employee benefits that are not mandated by federal law? For example, federal law does not require an employer to provide medical benefits to a spouse. So an employer can say, I'm only going to provide medical benefits to spouses of the opposite sex. Is that going to be allowed? Another question is how retroactive is the opinion? And what does that do for plans that were operating in accordance with DOMA for the past 15 years? If somebody died a few years ago and you paid a benefit to a named beneficiary under a beneficiary designation that wasn't consented to by the same-sex spouse, you now have to go back and get the consent of that same-sex widow or widower, or does that person now have a claim to the spousal benefit that federal law would give them? So there are all these retroactivity issues. Are you going to have to change your plan documents? Are you going to need IRS retroactive qualification relief if you've had any of these problems in the past? So there are all these retroactivity questions. There are transition questions. How much time do you have to fix your payroll processing? Now, presumably, if you're taxing people for the value of their spousal medical benefits, now you have to stop doing that. How much time do you have to stop? Can you sort of make up the past extra withholdings? If you've been grossing up people, paying them an extra payment to compensate for the taxes they have to pay, presumably you can stop that, But if those people are now going to go and get refunds on the taxes they paid, can you claim part of the refund for the gross up you had given them? All these nice, interesting, what I will call transition questions. Can someone come in and make a mid-year election change now that their spouse is deemed a spouse? Is that an open enrollment opportunity called a change in family status? Is a change in the law a change in family status? We think the answer is probably going to be yes on that, but it would be nice to get some guidance from the IRS. And then the really tough question is that the Windsor case did not address Section 2 of DOMA. Section 2 of DOMA lets a state say, I'm not going to recognize a marriage entered into in another state. And that overrides the full faith and credit clause of the Constitution. Is that section constitutional? For now, it's part of the law. So I practice in Pennsylvania. Pennsylvania has its own Defense of Marriage Act. And Pennsylvania will say, we're not going to recognize a marriage entered into in New York. So if an employee is working in New York, has a same-sex marriage in New York, works for a Pennsylvania employer with a policy issued under Pennsylvania law, and that employer say, I'm not going to recognize your New York marriage because our plan is subject to Pennsylvania law and we don't recognize a New York marriage. If a Pennsylvania employer hires someone who has a valid New York marriage, who then moves into Pennsylvania, which doesn't recognize the marriage, is that person still married? Under Pennsylvania law, they're not, but under federal law, they might be. So they might be married for the pension plan, but unmarried for the medical plan. That's a bit of a mess. And what happens if someone living and working in Pennsylvania goes to New York to get married and comes back to Pennsylvania? Is that marriage going to be recognized? So we have this complete mess when it comes to what I will call the cross-border issue.
Definitely. It was a landmark ruling yesterday and a victory for equal rights, but we still have a long ways to go before we have everything figured out. Once again, that was Susan Hoffman of Lidler. For more of her insight, be sure to visit employeebenefitscouncil.com, and of course, visit us at LXBN.com, where we have hundreds more of these LXBN TV video interviews, along with curated commentary from the Lex Blog Network's more than 8,000 lawyers, including a wealth of commentary on these two Supreme Court rulings. Thank you for joining me today, Susan.
Thank you.